Hello everybody and welcome to this month's Specifying Practice Group call. Dave and Lewis, over to you.
Thank you, Matt. This is Dave coming to you from southern New Jersey. Nice, hot, humid, sticky day here, so we're enjoying what's left of the summer. I think this may be our final week. Especially with the holiday here, we'll be toasting our visitors goodbye come Monday evening. Love to see them here, but also wonderful to see them leave. Lewis?
Well, I'm coming to you from sunny downtown Nashville, Tennessee, and I've been collecting grandchildren. I've had two born to two different families in just the past week. Last Thursday, little Alexander came. He's here in Nashville area, and yesterday Obadiah was born out in Seattle, so I won't get to see him for a while, but Grandma's out there with him. I did suggest to my son that a middle name for Obadiah would be Juan, so that we could call him Obi-Wan Metcalf, but they declined and called him Charles instead.
A good choice, I believe, and especially since it's a family name.
Yes.
All right.
Okay.
So, Lewis, you were the one that really came up with the idea for today's topic. So I think you ought to explain maybe a little bit overall, and then we can dive into this. But what we're really hoping is that everyone on the call today can actually share your experiences, because I think that the topic for today is something that has some very wide-ranging opinions and approaches. So
yes,
we can all learn from each other.
And some of those are eminently, there are different ways to skin this cat. I mean, there are some things that we need to do the CSI way, but there are other things that vary from state to state, region to region, and we want to get to talk about some of those things. But we hadn't done a session on what is now called Division 00, used to be called Series 0 documents, and so we thought that it might be appropriate to do one today. In the prior to the 2004 master format, the Series 0 documents were regarded as a separate table in the sense of like an omni-class table, and that the concept was that you could take those documents and that set of numbers and document titles and put together a front end for if you were going to write a specification organized with uniformat instead of master format, but you would use the same Series 0 organization for that. But with the advent of the master format 2004, the Division 0 now is more closely integrated into the overall scheme. So let's go to the first slide, and the basic concept that we're going to talk about today is that there's some stuff that we need to prepare and provide to bidders, or in some cases, or contractors, to get a project built that do not constitute the practice of architecture and engineering practice.
So what do you think, or what's the distinction?
Well, one of the things, of course, is that the state statutes do not control who can write bidding requirements, for example, that in the sense that only construction specifications have to be written by a registrant, whether they're architect or engineer, or they have to be prepared under the supervision in the case of unregistered consultants, like a food service consultant who might write their own specs, but just issued under the overall seal of usually the architect in that case. but the front end can be written by the owner, by various different people, or many of the documents. Let's say like that. So that's one of the things we want to talk about is what documents need to be sealed and which ones can be issued by somebody else.
Right. So the ones that don't need to be sealed are the ones really that are not affecting health, safety, welfare of the public, because it's really about the legal obligations to be able to construct a project.
Or the business relationship.
Right. Does that pretty much sum it up, you think?
I think so.
All right. So, CSI says master format breaks up the documents really into several different groups and subgroups. This was a new concept that was introduced by Master Format 2004 and persists today in the current version of Master Format. So the Division 00 are documents, and it's really split into two pieces. It's Procurement Requirements, which is everything in front of 005,000, and Contracting Requirements, which begins with the agreement forms in 005,000 and everything to the end of the division. Specifications are everything except Division 00. So, and specifications then are broken down into two subgroups: the General Requirements, Division 01, and then Divisions 2 through 49, which are all the technical requirements that the individual design disciplines are preparing. So we have the gigantic double red line to show the difference between procurement and contracting requirements and specifications.
Yes, and I, in my table of contents, do make a very strong division there because I want to make it clear to everyone what are and what are not specifications. We're getting some comments from several people that they're not able to see the slides.
They're not. Matt?
I am looking on my end. According to what I see,
I'm seeing.
Yeah, I was gonna say
I see them
on my end as well. I guess you got quite a few people saying they're seeing it. So I guess for those that are not seeing it, you may want to check to see if GoToWebinar maybe is minimized on your screen, or if you're using it on an iPad, you may want to close out of the app and try to relog back in.
Okay. All right. Well, let's go ahead then. So here's a brief list of what are contract documents. And again, we're going to see that in Division 0, we're going to have some things that are not contract documents, but basically it's the agreement, the conditions, the drawings, and the specifications, and maybe some other things that are named specifically in the agreement.
So the break point here then, if you consider agreement becomes the very first of the contract documents, that's starting in Division 0. So it's the 00500 or 5000 series of documents, which could be the agreements, and then from that point through the end of Division 0.
Yes, and we'll see that as we go through the outline in more detail.
Okay. So, go ahead, Louis. You were going to
No, I was going to let you do this one.
Okay, so these are the titles from Master Format that are the beginning of Division 0. So it's solicitation, instructions, available information, procurement forms. These are all of the titles that are identified as procurement requirements. So everything from the very beginning, 0 through 004999. I still trip over the 6-digit numbers. I don't know why. And then these are the titles of everything from that 005,000 through the end of Division 0. So we have the contracting forms, we have project forms, general conditions, supplementary conditions, all the revisions and modifications. Now, one thing I did want to ask, and Louis, because we didn't discuss this, but I'll ask your opinion. Project form, okay. Master Format gives us a place to collect project forms, and that could be virtually anything. But what I find is I end up using quite a few forms that are associated with Division 1 requirements. And because we're not often writing Division 00, I'm actually collecting all of those forms in Division 1.
Oh, you mean like a substitution proposal form?
Yes.
I usually publish those as an addendum or right at the end of the spec section that covers that. I try to make it so it's a separate page so it's easy for someone to make a copy of it and do it, and we offer an electronic version upon request to fill out.
Right, and that sounds like how I approach it as well, but CSI gives us, Master Format gives us the opportunity to collect all of those in a single place so that the contractor would have all of the forms associated with the project in one place.
Interesting. You can do that, but I don't know that I didn't, but it'd be interesting to see if anyone on the call here today has ever done that. And if you have, please stick up your hand and or send us a comment.
Okay, yeah, I would like, that would be an interesting poll question, which we didn't include.
True.
Okay, go ahead, Louis. You have some very strong opinions about this.
Well, as I say, I think it's very important that we distinguish for legal reasons and liability reasons which documents are, in fact, specifications and which are not. And because they're issued under seal, and of course that has very important implications. And then there's the second question is which sections are issued under which seals. Because there's sometimes some ambiguity as to who's going to write some of the sections that might sound like structural sections might in fact be written by the architect. And they can, on a small job, even write structural specifications. So that's not unheard of. And then, so is the organization strictly by master format, or I believe there are some states that require the table of contents to be broken down by discipline. And I was hoping that we could get someone to volunteer on that to state that. I was wondering, Sheldon is on the call. Is that something that's required in the state of Wisconsin? Would you stick up your hand and we'll unmute you?
Yes, if you're willing. Sheldon responded by chat saying, Minnesota, no. You have him in the wrong state, Louis.
I've got him in the wrong state.
Okay.
He's usually in the state of confusion. Well, let's bring up our first polling question, and that is, if we're talking about the seals, where do you physically put the seals? And we've got three options here on the cover. Do you have a separate seals page? Or, as I say, I believe there are some states that require the table of contents to be sealed. And again, perhaps someone will send something in. So while people are answering that, I see Steve Groth says that he does regularly use the form section of Division 00. Although some may think it unnecessary, I believe it's helpful to get all of this information into the bidder/contractor's hands, and this is a simple and logical way to do it.
There is something to be said for collecting all of those in one place.
Yes. Susan Clancy, on the other hand, says project forms should be those forms that are associated with subject matter in the general conditions that would be supplementary to the agreement, but forms that the contractor might have to sign about MBE participation or other such things, I suppose. Robert Swan says project forms, according to the comment in Master Format 204, is for forms related to contracting requirements. Wayne Smith says Iowa seals for spec has a line to indicate which sections are being signed for. And,
why don't we go back to the poll, Lewis, and see, here we are at the results. Seals page obviously wins with 63%, and 33% using the cover page for the project manual.
Which is traditionally what used to happen, especially in the old days before AIA invented the concept of project manual to describe the book, because somebody after nearly 100 years finally realized that there are things in the book that are not specifications, and only a handful do it on the table of contents. But as Dennis Elrod points out, there are some states that require the table of contents to be sealed.
Okay. Shall we go to the next
Yes.
topic? Okay, so seals page. I had never really seen or used a seals page until I ran into one client that worked out of Missouri. And she required a separate seals page for every licensed professional that was contributing to the project. What we had to do for that seals page for each discipline was to list every drawing and every specification section that professional was responsible for, and then they would apply the seal.
Now that you mention that, we have a comment from Jan Seaman who says that very thing. She says, I make a seals page for each discipline to seal and states that they are responsible for, etc. And then Charles Beasley says, let's see, in Louisiana you can put seals on the index sheets or seal each individual spec section. That would be...
Wow, that would be interesting.
To collect. Okay.
Wow, and if you had to submit 3 copies, signed and sealed, stamped?
Somebody's going to get tennis elbow out of it, or stamp elbow out of that.
I would think so. One of the things, techniques that we use typically, because many of our projects have quite a few consultants contributing to the project manual, we use in the table of contents, we identify the author of every spec section, usually by firm name.
In the line, as a line item.
Yes, because number one, it's self-defense, so that when we get the phone call and nobody pays attention to the table of contents, we can say, oh, that was not written by us, that was written by, and we can at least direct them to the right person, even if they don't know themselves. So, defensive spec writing.
Mary Noe says that on some public works projects, she lists every section available to a particular engineer, or applicable to a particular engineer or architect. Not always spelled out, but gets the responsible party's attention and clearly spells out responsibility. Responsible person signs and seals next to their list of spec numbers.
Yeah.
And of course, Jan Seaman again points out that she puts the consultant's company name in each section's footer, and I think that's a very good approach, and that's the one that I've used for many years.
Yeah, we see some mixed approaches on that, where often it's the architect that's trying to dictate the spec format, and they want every spec page to look essentially the same, so they end up either not using their own name or require all of the consultants to use the architect's firm name in the header or footer, wherever they put it.
Sheldon Wolf points out that he says that in one public sector office I worked in, the engineers were so frightened that each section was certified by a specific engineer rather than having all sections certified by the boss. I recall one section that was worked on by 2 engineers. The certification statement indicated which specific parts each engineer was responsible for.
From the same firm, Sheldon? That's pretty amazing.
It is interesting. Well, you know, the way our guys prefer to do it here is that the section on portable fire extinguishers, the fire protection engineer figures out what fire extinguishers to be specified and edits that part, and then the architects edit the part for the cabinets and so forth.
I've never experienced that one, I will tell you.
Okay. Anyway, let's go on.
Okay.
Well, there's a big difference between private and public bidding methods and bidding requirements. And in my experience, most public agencies already have very elaborate bid instructions and may even have bid forms that you just are given to the architect or engineer to fill in some of the blanks to make it project specific, but the basic language has already been established. Of course, most of us, if it's an architect-driven project, will use the AIA instructions to bidders. But there, as I say, some of those are already set up. And one of the interesting things about doing public projects is that many, many government agencies will include all of the bidding documents in as contract documents. And David and I were discussing this earlier when we were preparing for the session, and neither one of us can for the life of us figure out why they would want to do that, and whether there's ever been a lawsuit that hinged on having the instructions to bidders be a contract document.
Yeah, that whole issue I'll go back to the CSI old manual of practice, and some of you are going to remember the C-clamp and the ribbon and everything tied around all the contract documents,
which I drew for the manual of practice back in 1995.
Yes, you did mention that when we were talking about this, and that was a surprise then too. So, but the bidding requirements, if you remember the graphic, were essentially the tag on the ribbon that tied everything together. And the implication is that once a contract is signed, you just tear the tag off, which is all the bidding requirements, and you throw it away, because it was only there to solicit the bid.
The other image is that they're like the booster rocket that gets the payload into orbit but falls into the ocean and is a throwaway piece of equipment. Because even the bid form, even when it's publicly bid, there still may be some minor negotiation that takes place after the bid. For one thing, the owner's going to want to decide which, if any, alternates are going to be included in the contract sum. So there are going to be some changes.
Here's a question for you.
Okay.
You are just expert at this kind of thing.
Yeah, I'll bet.
This is from Dennis Burge, who's asking, how do you address the author of a spec section if the section is a component of each multiple prime contract for public work? Say, fire stopping.
That is a good question. And I think the answer to that one is that you move fire stopping to Division 7 and only let a single subcontractor do it, even in a multiple prime.
I like that idea. But in some states, you will find some strong resistance.
You get some pushback, yes.
Yes.
So the one thing that even if you're going to have multiple subcontractors applying the fire stopping or sealants for that matter, I have a note in my spec masters that says that all the submittals, that we're only going to look at one set of submittals for any given spec section. I don't care how many people install it, and they all have to use the same material. So you guys get your heads together, or gals get your heads together, and make up your minds what company you want to use.
Okay, we've got a couple more on the same sort of thread.
Okay.
This one from Sharon Noby, who's asking, what is the practice in sections where 3 professionals may be involved, like concrete, where it could be architectural, structural, and landscape?
Well, again, it depends upon who's going to write that. If it's a small, simple project, I've certainly done projects over the years, not many, but some very small projects where we, the architect, wrote the concrete specification. I even had to calculate some beams at one time. Haven't done that because my boss was too. I worked for a small practitioner, and the boss was too cheap to hire a structural engineer for the project. So we just figured out the beams and columns ourselves. But usually they can divide that up, and often what you can do is, for example, if I'm going to write. If I have architectural specification, concrete, or if the landscaper has some concrete, we can write the section to say what's unique to architectural or landscape uses, but refer them back to section 03-3000 cast in place concrete for the bulk of, what are the materials and how is the bulk of the requirements are in there.
Right, and that's often how we approach it too. So you have the main structural concrete section, which identifies all the materials. You may have a separate architectural concrete section that's there primarily for finishes or appearance, and a separate landscape architecture section that would be for paving or site walls or some other use of the concrete. And
I did a project back when I was in Cincinnati of some concession stands for a riverfront park, and we wanted board form concrete. Well, my structural engineer had no idea how to write a spec for that, so I wrote the specifications for the board forming, but they wrote the spec for the concrete that got poured into the board forms.
All right. I've got another good one for you.
Okay.
From Cheryl Dodd.
Wait a minute, it's my turn to ask questions and there's you.
You paused, you lose. Okay. This one's from Cheryl Dodd Hansen. What do you do when the owner or the agency's procurement documents are still Master Format 95 and the rest of the specifications are Master Format 2014?
You say, yes, boss. It really doesn't make a lot of difference. Since they are in a separate division, they're in Division 0. If they want to use the 5-digit numbers, it's not a big problem. It's a little more problem when occasionally you do work for a large I've done work for universities where they had some, not all, of Division 1's sections written, and we just included them in. And they were using the 5-digit numbering system, and we had gone to the 6. And so there I actually changed their numbers because I'm not changing the content. I felt free to do that.
Yeah, we have one that I just proposed on, which is for Department of General Services here in Pennsylvania, and they have exactly what you're saying, Cheryl. They produce Division 00, but it's all 5-digit numbers. They also have their own standard Division 1 which is also 5 digits. And the difficulty for us is you can't rewrite the stuff because Division 1 is referencing Division 00, and 0 is referencing, in some cases with the DGS jobs, is referencing Division 1. So trying to rewrite that and make sure that you get all that coordination right, you'll probably lose. So it's better just to accept it, put it in, deal with it. The contractors will figure it out.
Yes, and by using a different page format from what your public agency does, then you can, it's a little easier to disassociate yourself from the dumbness.
A polite way to put it. Okay. So we talked a little bit about this, the bidding requirements. If you pay attention to CSI's philosophy, all of the bidding requirements, everything before 005,000 in the project manual, should be discarded when the contract's signed, because it's only there for the purpose of soliciting the bid. And if you have information in the bidding response or in the proposal response that should become part of the contract, then it should be transferred either into the agreement or elsewhere in one of the contract documents. Because you don't necessarily want to include everything that is bidding as a contract document, because it really becomes meaningless once that contract is signed. So, and one of the things that we see pretty regularly is, especially from some of the specialty consulting disciplines, and I can think of one in particular that does this pretty routinely, is that they will actually write bidding requirements into technical specification sections because they are not in control of Division 00. So it's their way of trying to insist that the bidding requirements that they believe are necessary are included, but it's also a way to...
Even including bid forms.
I haven't seen them go that far.
Oh, I have, yeah. I've run into this most often with signage consultants and food service equipment consultants. And yes, not only do they want to rewrite the bidding requirements, they will also rewrite the general conditions.
Yes, well,
bless their hearts.
Can happen. Yes.
Let's go to the next slide.
All right, we can do that.
I think Tommy Smith has anticipated this slide. He asks, is a contractor entitled to rely upon available information, or if the available information differs from actual conditions, is the differing condition considered unforeseen, and thus the contractor would be entitled to a change order? So the next category in master format is for information available to bidder or contractor. And of course, the most common one is the geotechnical reports that we all rely on a lot. And yes, people are allowed to, the structural engineer has the legal right to rely on the accuracy of that report when interpreting it to design the foundations. Similar to the contractor has we get in the whole issue is that a geotechnical report, because it's not prepared by the architect or other design professional in responsible charge of the project, we can't include that as a contract document. Now, some structural engineers, bless their hearts, will refer to it and tell the contractor in the earthwork section to comply with the recommendations of the geotechnical reports, which is not legal, and sometimes it's not practical because the geotech report may have 2 or 3 alternative solutions to a given situation. I had when I was a co-op back in the late 60s, I was working on a project that was a little strip mall, and they'd done 4 test borings. The contractor moved onto the site, started excavating, and very soon found right in the middle between those 4 test borings a buried steam locomotive.
That would be an interesting find.
And you know how big a steam locomotive is? They are enormous and complicated. So they had to cut this thing apart and haul it out piece by piece and then put engineered fill in. I don't know why they didn't fill the boiler with concrete, but well, yes, that's kind of an extreme case.
I'm surprised they didn't claim it as an historic artifact and shut down the site.
Yes. Well, we'll tell another time about bones that I found excavating for an elevator that we were adding to an old building. But that's a story for another day. So these things are this information, because it's not verified or provided in the first place, generated by the architect and structural and the engineers of record. It's made available, but they are not contract documents and should not be referred to. The record documents that here refer to record documents for existing facilities when you're adding on to it.
Yeah, because and the condition assessments, that happens a lot too when you're doing or when you're changing owners for the buildings, that someone considering buying the building will go out and hire an independent third party to do a condition assessment. And oftentimes those condition assessments provide a good deal of insight as to what needs to be done for the project, although it shouldn't necessarily be considered a contract document unless it's specifically included or referenced.
Steve Groth addresses our question about procurement requirements in the contract documents, and says the state of Wisconsin does include that. In my opinion, this is beneficial only in that their master documents don't always list requirements in the proper locations. So we'll
okay.
just...
And Monique O'Dwyer, I hope this discussion here on the available information has addressed your questions. If you have something else, maybe you can just let us know. Okay, let's go on to the next one, I think. Well, we have to let Kevin O'Byrne correct me.
Oh, okay.
All right. So
he knows enough to do it.
And he does. He points out that I reference technical specifications. There are no technical specs. All of them are technical. Yes, thank you, Kevin.
Yes, I let you slide on that one. I usually call them products specs, but that's kind of gone out of fashion these days.
Okay.
May not even be politically correct.
Really?
Depending on who you hang out with.
Okay. So you get to explain all of these conditions of contract, Louis.
Well, before we do, we have a poll question.
All right.
About getting the conditions of the contract from the client. So, Matt, would you put that up? It's actually the number 3. It's the last one. There you go. Wonderful.
Okay, you never get conditions of the contract from your client? Is that what you're saying?
It's always a pain. It's always difficult. But I'm curious about other people's experience with that. So we'll give you an opportunity to vent, friends and neighbors. You can express your frustrations. I had one project where the supplementary conditions were passed back and forth between a lawyer that was on the board of the directors for the Cincinnati Art Museum and the contractor. They kept passing it back and forth, trying to come to agreement. They finally got lost somewhere in the shuffle, and we just went ahead and built the building and got it done. And worked out okay. So how are our results?
Okay, well, we have the I won't say majority, the plurality, amazingly difficult. They come in late, 45%. 27% like pulling teeth without anesthesia, and 18% rarely get them. I want to know who those folks are that never have a problem, at 10%. Louis, I think you skewed this poll. You made it decidedly negative.
Did I use some slanted language? No.
This would definitely not pass muster in a scientific poll, let me tell you. But I think it gets the point across that that we rarely do see general conditions. We have the same frequency of seeing the contract between the owner and the contractor, which really complicates making Division 1 consistent with whatever the owner actually puts in place for construction administration.
Yes. So back to our slides.
All right. So you're going to explain this, the conditions of contract.
If you have general conditions, those are the standard form conditions that are published by AIA, by EJCDC, the Engineers Joint Construction Documents Council. See, I can how that rolls trippingly off my tongue, and by consensus docs. And then the supplementary conditions are a way to tailor standard printed forms to be either owner, client specific, or project specific, or both. And in all cases, they cover the business topics. They cover how much insurance you have, whether or not you have liquidated damages, how the contract is terminated, and the general warranty, and so forth. Now, in my experience, many of the owner-written conditions of the contract are combined with the agreement form. And the issue with those, and we have done a section on this a little bit about some of the difficulties in going through them to make them, to edit our Division 1 to be consonant with them. A lot of owner-written general conditions, I was just looking at a set last week, had things like they were micromanaging the submittals rather than just saying, okay, you have to have submittals and you can't do work until they're approved, and some of the strategic level of decisions. They were down to the point where they were saying, we want 6 copies of shop drawings, and of course that doesn't work with my Division 1 that says we're going to send in we want electronic copies for processing in new forma. So some of those things have to get ironed out.
So what do you do in that case? You require the electronic copies and then print out 6 for the owner?
Is anybody listening?
Go ahead. Nobody's listening.
Okay. Sometimes we ignore some of those micromanagement things, and we just go ahead and even the owner will tell us that. They know they have documents like that, and they'll just say, oh, just do it the way you usually do it. Literally.
Okay, but do you find that ends up creating additional work for you once you get into CA and you're having to answer the contractor's questions?
Not really.
I see this and I see that. What is it that you really want?
Not really, because they don't pay that much attention on a practical level to the conditions of the contract unless something goes awry. Badly.
I can't believe you just said that.
It's true. Of course, and again, we did compare the AIA documents with the consensus docs, and one of the biggest differences is the definition of contract documents, because in the consensus docs, with their general conditions, once the design professional has approved a shop drawing, it becomes a contract document.
Yeah, that's one of the major differences for consensus docs, for sure.
But and we do have a whole session on that if you're interested in going back to last year and looking that up. In addition to the kind of the business, typical strategic level business decisions that are in the conditions of the contract, many public projects have to have things like prevailing wage rates and MBE or DBE requirements, no drug use on the job site, that kind of, all kinds of certifications and requirements that are really supplements to the conditions of the contract, even though they may not be formally called that. And ultimately, the responsibility has to be the owner. I have caught people in my offices, different ones, attempting to write supplementary conditions, and I have severely chastised them because we can't do that.
Why is that?
Well,
what do you mean you can't do that? Anybody can sit down and write supplementary conditions, and it's just more text.
It is, but in any state, only a licensed attorney can write a contract between two other parties. Either party can write the contract. But if a third person, outside person, writes the contract, that person has to be an attorney. So we're not attorneys, we're not licensed to practice law, so we cannot write the supplementary conditions. We can advise the owner about some things that we think should be included, but ultimately it's up to them and their legal counsel to decide what they're going to agree to.
Okay, which brings us to, are you sure about that? Because oftentimes when we go to the owner and we take our AIA questionnaire form and say, Mr. Owner, here it is, fill out this form. We know it's 14, 15 pages long and it's pretty onerous, but we expect you to have it back to us tomorrow so we can finish this conditions of the contract for you. The response we normally get is exactly what it says here. Do whatever is normal. And that applies to insurance. That applies to liquidated damages. That applies to a whole raft of things which the owner should really be controlling the decision. So we find ourselves often in a position of actually drafting supplementary conditions and submitting them for review, suggesting strongly the owner have their counsel review the conditions, and then waiting for a response, which may or usually never comes.
Or well after the project's issued for bid. Yes, on a practical level, we do that from time to time. But there are a couple of things, especially like insurance limits and the liquidated damages, that if we just write that unilaterally without getting the owner's consent, and then something goes wrong, they need to collect on the insurance, they need to collect the liquidated damages, and it ain't enough, guess who's going to have to cough up the difference?
Let's hope not the architect.
Going back a couple of slides, George
George Everding? Yes.
Everding, talking about the right to rely, refers us to the Spearman Doctrine. And that is an essential and bedrock decision that everyone in this business should know about. And basically it says that if the contractor does it according to the construction documents, the owner has to pay him and be satisfied if it does, even if it doesn't work, as long as it conforms. So
Right. It's essentially the owner's implied warranty by issuing the documents that if you provide what the documents say, you've met the requirements of the contract.
We're getting a little close to time there, David, so let's go to the next slide.
All right.
And finally, we're down to Addenda. And let's pull up the last polling question. I was surprised when Dave and I were talking about this the other day that he was, the firms that he's been associated with did not commonly seal Addenda. So I want to find out what this august body thinks.
I think they're siding with me, Louis.
Well, we'll find out.
So, yes, we'll see. But I think you're going to see the majority probably have never seen a signed or sealed addenda. And no.
That could very well be. Michael Wilson says, can we get more details on the Spearin document? It's doctrine. I'm sorry, I may not have enunciated clearly. It's a legal decision that was made on a lawsuit back in 1914, I believe, and I think we might have to, at some point, we will address that. But if you have any real questions on it, I'll tell you the person that I know that knows the most about it is Tommy Smith, and if you look him up in the CSI directory and address an email to him, you'll get more than you bargained for.
For as much as you seem to know about it, were you there as an expert witness testifying that?
That was slightly before my time.
Okay. So the results of the poll...
Although I do own a banjolin that was made that year.
Aha. All right, so the results of the poll was decidedly favoring no. 67%.
But it is a common practice by some people.
Only the ones that you work with.
Well, and Richard Dockman says the addenda are part of the contract documents, especially with work with DSA or OSHPD in California. They must be stamped and signed.
Yes, that's OSHPD.
And Larry Whitlock says, my understanding is that any document issued by architect of record should have a seal and signature. And Sheldon points out the requirement for certification of addenda varies from state to state. Some states require essentially everything issued from an architect's office to be sealed, and some don't address the issue. One state we work in prohibits certification of bidding documents. Interesting. So let's go back to our slides.
Okay. So I know that you have one topic up here, the multiple work packages, and you probably want to address addenda as it relates to that.
Yes. Last fall, the CSI published a new practice guide on organizing, producing, and managing documents in multiple work packages for fast-track construction. And one of the things that the task team agreed on there was that if the design professional felt that a formal issuance document was needed, that we could actually use an addendum. That an addendum is usually defined as a change issued before execution of the contract, but it's also the feeling was that as long as it's being issued before the final establishment of the contract sum, that would be appropriate, but it's an option.
Okay, and I'm glad you used at least the word addenda. The other proper term, as far as I'm concerned, is modifications, which happens after the signed agreement, addenda before the signed agreement. Yes. But what we often end up seeing is a whole collection of other terms used for essentially the same thing. One of the ones that's predominant is bulletin, which is really not defined in any of the standard conditions of contract. So just be careful of that. I like the Louis, I know you added this in, the concept for the conform documents, and that's something that I hope the architects pay particular attention to, because under AIA agreements, conform documents are actually an additional service. And you had an experience, I think you said, because you use Newforma as a way of producing conform documents.
Yeah, first let's define our term. What we mean by this phrase is, I have found out working on some task teams with the Institute that it is not common throughout the U.S., is that it means a set of sealed and signed documents that have all of the contract modifications incorporated into them as of the date. So if one drawing might be revision 4, the next drawing might be the original drawing, the next one might be revision 2, so that at the end of the job you have a set that incorporates all of the change orders, all of the ASI changes, all of the formally adopted changes. This is quite different from a set of record documents that talks about hidden things or the locations of the conduit that were shown diagrammatically on the drawings, the actual locations. And the project information management software called Newforma actually has a subroutine that if you set up the drawings with the right information in the metadata, the program will actually select the latest version of each individual spec section and drawing to have this conformed set. And because almost all of our clients demand it, we find that issuing narrative type addenda and little 8.5 by 11 sketches and stuff, sometimes are hand drawn, that's not an effective use of our time, that we're time ahead to just go ahead and turn on the track changes feature in Word for the specs and to cloud up the changes and reissue whole spec sections and whole drawings. Especially these days, since we're only sending out PDFs anyway, electronic documents, rather than printing them. And that way, you've got a cumulative set that has all of the official contract modifications embodied in it.
Okay, are you seeing that, because you mentioned some of the change orders also being incorporated? We most often see conform documents as an issue that's created at the time that the contractor signs the agreement. And beyond that, then it's tracked as record documents. But it sounds like you're suggesting that it could go to the end of construction.
Oh yes, and because I think there's a distinction there between what we change, because they're, as the architect and engineers of record, that we implement changes to our contract documents, which only we can change, as opposed to the record documents that the contractor is maintaining.
Okay, so I think that there might be two different approaches to conform documents then, and so if we're using that term, we need to probably be careful how it's being used to understand at what point we're talking about during the contract.
Yeah, and that's what I was saying, is that so even in a bidding situation, rather than describing the changes in a narrative format like we used to do for many years, we'll just reissue the spec section or reissue the drawing with the revisions indicated on them.
Okay.
And then if it's a bid situation, we will accept all those changes so that when it goes out for actual construction, it's a clean set. But then we continue to keep the conform set up to date because of the change orders and ASI changes that are officially authorized.
Right, which brings us to the end.
I didn't know if we were going to make it. We had a lot of comments and a lot of questions that we were not able to address, but we appreciate so much everybody sticking with us for this session and all of your comments. David and I get printouts of them afterwards, and so we do look them over. And if there's something specific, feel free to contact either of us by email, and we'll try to share our ignorance with you.
And just so you understand the magnitude of the number of comments, we had 103 questions today, and we didn't even come close to addressing all of those. We had over 200 on the call, at least at one point, and we really appreciate everybody joining us. It's our pleasure to be here to help lead the discussion and to field all of your questions, and hopefully everybody learned something out of this.
And as always, we're looking for ideas because this is your program, and we want to meet your requirements. In November, we're scheduling a session on paint with a technical representative of one of the major paint manufacturers, and I think that's going to be very, very informative. But if you've got ideas for something, why, be sure to let us know.